My children were removed from my life on an allegation. No charge followed. No further action. It is recorded in writing that there was no safeguarding concern. It took 101 days to see my son again. I have not spoken to my daughter for 2.5 years. Nobody has ever had to explain why. This is how that happens. Over the next 20 minutes, I'm going to walk you through it. What alienating behavior actually looks like. What the professionals and the courts already say about it. Why 4 different agencies can each give you the correct answer and still leave a child without a parent, and what would need to change. This isn't only my story. Change the names and the dates, and it belongs to thousands of families. The shape stays exactly the same, and if you have never been near a family court, stay with me anyway. About 4 in 10 marriages here end in divorce. Almost nobody believes any of this until they are standing in the middle of it. Most of us don't. Before I go any further, I need to be precise about something, because if I'm not, your mind will fill the gap, and it will fill it wrongly. The allegation was not about my children. It never was. Not once. Not at any point. No concern about how I parented. No concern about their safety with me. No investigation into my care of them. It is recorded in writing that there were no safeguarding concerns regarding my children that closed. That is not in dispute, so follow what happened next, because it makes no sense until you see the mechanics. There was an order concerning the other adult, not the children. The adult, and I obeyed it carefully, completely. I kept my distance precisely so that nothing could be said of me, but here's the trap. Everything about seeing my children ran through the one person I wasn't allowed to approach. The arrangements, the messages, the handovers, the answer. So obeying the order, doing exactly what I was told, meant I had no route to my own children at all. And when I asked, through the only channels left, the answer that came back was always the same. The children don't want to see you. That sentence is unanswerable. You can't test it. You can't reach past it. And nobody, not one person in any agency, stepped forward and said, let's find out if that's true. Nobody was ever asked to check. I have never argued that protective orders shouldn't exist. They save lives, and I would take none of them away. I'm saying that when one is in place, someone must stay responsible for how the children still see their parent. Because otherwise the order does something no court intended and no judge ever wrote down. Now separation brings out the worst in people. Parents say things they regret. Some go rigid, defensive, overwhelmed. That causes real pain. It isn't automatically alienation. The difference is 3 things: pattern, purpose, and impact. One angry comment after a terrible day is not months of repetition that teaches a child to fear a parent. A parent with genuine safety concerns is not a parent. Using vague claims to control contact. A child unsettled by separation is not a child recruited into an adult's campaign against someone they once loved. And it's missed constantly because from the outside it looks ordinary. I'm only listening to the child, I'm just protecting them. Sometimes that is completely true, sometimes it hides a pressure the child doesn't feel free to name. So labels must be handled carefully. Calling someone an alienator without evidence does harm. Ignoring a clear pattern does harm too. It almost never begins with one dramatic act. It accumulates. Constant criticism of the other parent in front of the child, blame for the separation. The money, the stress, guilt for enjoying their time away, calls and visits restricted with no safeguarding reason. Adult legal details handed to a child who should never carry them. Encouragement to report back, to take sides. Affection treated as betrayal. History rewritten until a once loving parent becomes worthless or dangerous. Rejection rewarded. Warmth withdrawn when the child shows love for the other side. Much of it is nearly invisible. A sigh when the other parent is mentioned, a cold silence after a happy weekend, a quiet, repeated, "I suppose you'd rather be there," and the child learns something devastating, that loving both parents causes conflict. So they self-censor. They stop mentioning the other home. They hide the photographs. They say whatever keeps the peace. And eventually they may appear to reject a parent entirely of their own free will. When that rejection was shaped quietly over months, that matters more than anything else, I will say. Because that is the moment the system stops looking. So what do you actually do? You've committed no offense. Nothing has been found against you, and you cannot reach your own children. There must be someone whose job this is. I went to the police. They said, "This isn't a police matter. Speak to social services." That's true. It isn't. I went to social services. They said, "We're not mediators." There's no safeguarding concern here. See a solicitor? Also true. It isn't their role, and there was no concern. That's the whole point. I went to a solicitor, and a good solicitor tells you the honest thing. I can write to the other side. I cannot make them reply. I cannot make them agree. If they don't engage, there is nothing to enforce, because there is no order yet to enforce. Also true, so the advice is, apply to court. A child arrangements order, and that's the right advice. It's the only door left, but look at what's happened. You've been passed from the police to social services to a solicitor, to an application, and every one of those people gave you the correct answer. Nobody was negligent. Nobody was obstructive. Each was working properly within their remit. But the remits don't touch. There is no body in this country whose job it is to say, "This parent has no findings against him. He cannot reach his children, and that needs solving this week." That job does not exist, so it doesn't get done. And here's the part that costs you everything. All of that took months. Not because anyone dragged their feet, because that is simply how long it takes. To be told 4 times that it isn't their department and then to join the queue, months is not neutral time. Months is exactly how long it takes for a bond to be reshaped in a child's mind. By the time you finally stand in a courtroom, you are not asking for what you had. You are asking someone to repair what the weight has already broken, and then you're told that children are reluctant, and that reluctance is treated as the finding rather than as the consequence of the delay that produced it. The system creates the situation, then it treats the situation it created as the reason it can't act. That is the whole thing in one sentence. There's a phrase you'll hear if you go looking. Parental alienation syndrome, and the Family Justice Council rejects it flatly. I want to be careful here, because this gets misreported constantly, usually by people with something to gain either way. They are not saying it doesn't happen. They are saying it isn't a diagnosis. Syndrome implies a condition in the child, identifiable from a checklist, where spotting the symptoms proves what caused them, that reasons in a circle. It isn't in any diagnostic manual, and historically it was used to wave away real abuse. So they threw out the label, and I agree with them. But read the same guidance, and you find the other half, where alienating behaviours are found. The harm to a child can be significant and enduring. The shift is from diagnosing a child to establishing facts about an adult's conduct. And honestly, that should be better. A syndrome needs an expensive expert to certify it. Behavior is something that judge can find on evidence. They even set out how. You start with the 3 R's. Reluctance, resistance, refusal. How is the child actually behaving towards that parent? But, and this is the part that gets lost, the 3 R's prove nothing on their own. A child can refuse for excellent reasons. A child who is frightened should be listened to. There are 2 more limbs. Is the child's response justified by that parent's own behavior towards them? And has the other parent behaved in ways that caused the rejection? All 3 have to be examined. Not one, here is my problem. That guidance was published in December 2024. My final hearing was in May 2025. I raised the 3 R's. I raised the test with the court, and with Cafcass it was not addressed, not rejected with reasons. Not weighed and dismissed. Karma simply not addressed, and I want to be fair. I don't know what was in anyone's mind, and I'm not accusing any individual of anything. But this is the pattern I keep finding. The framework exists. It is published. It is current. It is theirs, not mine. And a parent standing in a courtroom pointing directly at it can still watch it go unexamined. That's the gap, not between what's harmful and what isn't, between what is written down and what happens in the room. I'm not asking you to take my word for any of this. Cafcass, the body that advises the family courts, defines alienating behavior as an ongoing pattern that can undermine or destroy a child's relationship with their other parent. And in 2020, the Court of Appeal added the point that matters most. The manipulation does not have to be malicious. It does not even have to be deliberate. It is the process that counts, not the motive. That single sentence removes the commonest defense there is. I never meant to, and none of this is new. As far back as 2017, the then chief executive of Cafcass was describing this publicly as a form of neglect or abuse, and comparing it as a public health issue to smoking or drinking. That was 9 years ago, not because the people in it are bad, because of how it's built. First, emotional harm leaves no bruise, no photograph, no hospital record, to no threshold it crosses, so it sits below the line at which anyone is obliged to act. To karma, physical harm gets a response. This gets a review date. Second, everybody holds one fragment. The police see an allegation. The school sees a domestic matter outside its remit. The GP sees 10 minutes. Social services see a snapshot. The court sees what's put in front of it. Nobody holds the whole. Third, everyone is risk-averse and rationally so. Saying no carries a risk. Saying nothing never does. The safest step for the institution is almost never the bravest step for the child. And fourth, the money, and people get this part wrong. Nobody is sitting in a room profiting from misery. The truth is duller and worse. The funding flows towards conflict. Legal aid was stripped from most private family cases in 2013, so parents represent themselves in a system built for lawyers. Early help, mediation, counseling, therapeutic work is precisely where the money isn't, so families are pushed down the adversarial road. Because that's the only road that's paved. Follow the incentive. Not a conspiracy. Here's what happens when a family breaks up in this country. There's the divorce itself. One process, the arrangements for the children. A second, the property and the money. A third, protection from abuse or harassment, if needed. A fourth, and child support, run separately again through another agency entirely. 4 application forms, 4 respondents, 4 sets of witness statements, the same family, the same facts, the same worst year of their life, told over and over to people who never compare notes. You'd assume there's a reason for that. That someone decided children must be kept apart from money and protection apart from both. You'd be wrong. Lady Hale, the former president of the Supreme Court, the woman who wrote the Children Act 1989, the law every one of those hearings claims to serve, has said the reasons are historical and hard even to identify, not designed, not decided. Inherited, she called it in most cases, completely unnecessary. And her reasoning is the simplest thing in the world. That's not how life works. Nobody's separating experiences, the children, the house, the money, and the fear, as 4 unrelated problems. They arrive together in the same week, in the same head, at the same kitchen table at 2 in the morning. Only the system pretends otherwise. She set out the fix too, a single application form. A single set of witness statements, then serious triage by the court. What can be settled now? What genuinely needs a hearing, and one process to resolve it together. One family. One case. One judge who can see the shape of the whole thing, so understand what that means. When I say nobody held the whole picture, that's not bad luck in my case. That's the design, or rather, it's the absence of one. The fragmentation is not a safeguard. It's a leftover. It took 101 days to see my son again. My daughter was 11. By the time the process reached her, the months had already done what months do. No guardian was appointed to help rebuild what the delay had broken. She was left to come back in her own time. I have not spoken to her for 2.5 years. Not 2.5 years of a finding. 2.5 years of nothing being found, and nothing being done about the fact that nothing was found. And in all that time, not one person has had to answer for it, because nobody is responsible for the whole. The police closed their part. The council closed their part. The court ruled on what was in front of it. Everybody did their job. And a child lost a father. They call it child-focused, but child-focused would mean asking what her life actually looked like before. Who fed her? Who taught her? Who she ran to? That history exists. It was never examined. What was examined was a snapshot taken at the worst moment. And treated as the whole picture, I have to be honest about something. I hear the same sequence from parent after parent, an allegation, a removal. Months of silence, contact that never recovers. Conflict that never ends, but the parents who find me are the ones it happened to. That is not proof of how often it happens. I can't give you a number. Neither can anyone else, because nobody counts it. We count children bereaved by a parent's death. Around 26,000 a year in this country. We do not count the children who lose a living parent this way. No national figure exists that absence is not neutral. If you don't measure something, you never have to fix it. You cannot have a scandal without a statistic. And for scale, this is not a rare event at the edges of society. Around 4 in 10 marriages here end in divorce, over 100,000 a year. This is a road running through the middle of the country. Most people won't believe a word of it until they're standing on it. I didn't. Count it. Publish it. How many children and how long they wait. Give it an owner, where a parent has no findings against them and cannot reach their children. One named body must own that problem and act within a fixed period, not 4 correct answers. One responsible one, where a protective order is made between adults and children are involved. Root the contact arrangements independently and review them independently, so that complying with the order can never itself become the barrier. Consolidate the proceedings, one family, one case, one judge. As Lady Hale has already proposed, the single-family court was created in 2014. We unified the building. We never unified the process. Apply the test that already exists, not just the first limb. All 3, and where it's raised, address it in the judgment with reasons. A framework nobody applies is not a safeguard. It's a document. When an investigation ends with no charge and no safeguarding finding, restoration should be automatic and swift. Not another application, another queue, another year. The system has an emergency brake. It has no accelerator. Interim contact should be the default while a case is heard, unless there is evidence of risk, not the reward for surviving the wait. Enforce the powers that already exist. Courts can already act on breached orders. Those powers are barely used. This needs no new law. Only the will to use the old one. And where a relationship has already been damaged by delay, order therapeutic reunification support. Don't hand a child the impossible job of repairing it alone and then call the result her wish. Protect children from real danger. First, fast, always. I would take away none of it. But where there is no danger, no charge, no finding, nothing, someone should have to explain why a child is still without a parent. Because here's the thing I keep coming back to. The guidance exists. The research exists. The court judgments exist. The reform proposals exist. Cafcass has known for years. The judiciary has known for years. The most senior family judge this country ever produced. Name the problem and name the fix. Knowing was never the problem. Doing is. If you have lived any part of this, you know how lonely it is to be told everyone followed the process. So let me say what I needed someone to say to me. It was not your imagination. It was not your fault. And you are not the only one if this reached you. Share it with someone who needs it, or someone who still thinks it couldn't happen to them. Change begins when enough of us refuse to stay silent. You are not alone. This is the silent parent.